Okay, so welcome back to Unredacted Feather for this incredible special edition that's going to contain news that many of you have been waiting for on pins and needles. So hang on to your hats. You might notice today that we have on a special outfit. I couldn't be prouder to be an American, and I couldn't be prouder to be a member of the bar, because even though we are involved in a legal system that sometimes falls short, has its own shortcomings and failures, today, we have a praise not only for our Creator, the Lord, God Almighty, but also for the First District Court of Appeal. Unbelievable. Hang on, because here comes the story. Yeah. Amazing order I'm going to show you, and Elsie is going to put up in its entirety. This is hot off the press from the District Court of Appeal in the great state of Florida, August 7th, 2024. The Honorable Justices Bilbrey, Nordby, and Tannenbaum concur unanimously in this decision, and petition for writ of prohibition that we're going to go through you here line by line. The writ of prohibition precluding the Honorable Craig DeThomas's from presiding further in the Hales v. Preston case has been granted. In other words, the writ has been issued. The District Court of Appeal has officially proclaimed that the Honorable Judge Craig DeThomas's will no longer be permitted to preside in this case. And so, if you'll hang on to the very end, we're going to have some exciting conclusion for you to answer the question that many of you want to know. The Honorable Court, the First District Court of Appeal. So let me just tell you briefly the structure of our court system. We've covered it in other videos, but maybe you didn't get to see it. So you have a county court that handles relatively minor matters compared to some of the other things that are covered in court. Now, they're important to the litigants, right? If you're accused of a misdemeanor, or you have a small claims case, or you have a dispute, landlord-tenant disputes are typically handled in county court. Those sorts of things are handled by the county court. Injunctions, felonies, more significant cases are handled in the circuit court. And circuit courts, typically always your county judge will represent one county in the state of Florida. Circuit judges will represent or have the authority to act in a number of different jurisdictions or counties throughout their jurisdiction, which encloses the entire circuit that they are a circuit judge in. So, for example, the 8th Judicial Circuit here, where we are located, includes Alachua, Baker, Bradford, Union, Levy, and Gilchrist County, and I hope I didn't miss anybody. So a circuit judge has the authority to operate in any of those counties in its circuit judge capacity. So in this case, an injunction, domestic violence injunctions, although sometimes are handled by county court judges who are dual sworn to serve in both capacities, generally speaking, are under the jurisdiction of the circuit judge. It's certainly under the jurisdiction of the circuit court. So now in the state of Florida, it wasn't long ago that in the event there was an appeal from the county judge or a county court, the county court appeal would go to the circuit judge or circuit court. But now they go directly to the District Court of Appeal. And it's always been the case, at least since I've practiced law for the last 3 decades, or most of 3 decades, that the circuit judge's decisions, or circuit court's decisions, are reviewed and appealed to the District Court of Appeal. And then, of course, there are 5 of those in the state of Florida, 5 district courts of appeal, and above them sits the Florida Supreme Court. And the Florida Supreme Court is the ultimate court for the state of Florida, of course, with the exception of the United States Supreme Court, whose laws apply to everyone in the United States of America. Now, interesting little tidbit as we're going to get back to this story, or this ruling. An interesting piece is that the state of Florida and any other state in our democracy can expand the rights of an individual. They just can't restrict them less than what the Supreme Court of the United States provides. So, for example, we could have rights that are extended, rights that are greater than what might be provided by by the Constitution as interpreted by the Supreme Court of the United States. All right, hang on. We're going to get back to this writ in just a minute. So here we go with the Honorable First District Court of Appeal, State of Florida, number 1D2024-0550, petition for writ of prohibition, original jurisdiction, per curiam. And now we're going to get into the text. What did the court actually find, and why did the court find it? So I'm going to ask Elsie, and I tell you, everybody should be as blessed as I am to have an Elsie in their life, somebody who encourages them. Frankly, this wouldn't be happening right now if it wasn't for her encouragement and support. So shout out to Elsie. Also, before I get into this, and at the end, once I've read it, I'll tell you about my conversation with Jeremy earlier. But, you know, thank God for the encouragers, right? The people in our lives. The fact of the matter is, I wouldn't be an attorney. I would have never gone to law school, but for Ted Burt, who married my mother when I was 18 years old, and is just an amazing, amazing man, and I just couldn't give enough kudos for this guy. So thank God for the encouragers. May we all be encouragers for others. Is the text, so she's going to put it up, and we'll go through it line by line, because while it's very short, less than a full page long, although it exists on 2 pages, it is very powerful. The words of the court are succinct and, in this case, demonstrative of the urgency that was necessary in this case. What you're going to hear is this was an extreme remedy. So let's get into the text of the motion. So Elsie, if you'll put that up for everybody watching, that would be great. So it begins with Jeremy Hales. And so, frankly, you and I would have never met if I hadn't met Jeremy Hales. So, first 2 words, Jeremy Hales seeks prohibition to the trial judge presiding over his civil suit, because the judge should have recused himself on one or more of Hales' motions to disqualify. Now, you'll probably remember there were 3 of those. Back to the document. This court grants Hales' request and issues the writ, finding that he has demonstrated a sufficient basis for disqualification in possibly his second, but certainly his third motion. And the court cites to a case here, see State versus R.R. Commissioners of Florida, 84 Southern 2nd, 444 at page 445. Now, this is a Florida Supreme Court case from 1920, more than 100 years old. See State versus Railroad Commissioners of Florida, 84 Southern 2nd, 444 at page 445, a Florida Supreme Court decision in 1920. So what did the Supreme Court, the highest court in the state of Florida, say in 1920? Well, according to this decision, it explained that the common law writ of prohibition is, or quote, is an extraordinary judicial writ, extraordinary, which may be issued by this court, quote, to restrain the unlawful exercise of judicial functions when no other adequate remedy is afforded by law, period, end quote. What a statement. That's powerful. That's powerful words. The court goes on then to cite the case, and I'll probably blow the pronunciation here, but Jofen v. Parks, a 1933 decision, so a case that's almost 100 years old, from the Supreme Court of Florida once again. That case is at 147 Southern 273 on page 274. States, quote, or this decision that the District Court of Appeal is referring to, the reason the District Court of Appeal is citing this case is for the proposition that's contained in the parentheses, which you see, describing that it is appropriate for a court to issue the writ of prohibition, quote, in emergency cases to forestall an impending, present injury. End quote. Close parens. An impending present injury. Extraordinary judicial writ. So the court here is, the District Court of Appeal is recognizing how rare such a decision is, that this is extraordinary and should only be entered when it's necessary to forestall or preclude an impending present injury. Calling it an emergency case, a situation where someone can go on and suffer unless the District Court of Appeal, in this case, acts. And they did. And we thank God for that. So now turning to the second page, we rely on the Supreme Court's holding in Bundy v. Rudd, where the court explained, quote, when a judge has looked beyond the mere legal sufficiency of a suggestion of prejudice and attempted to refute the charges of partiality, he has then exceeded the proper scope of his inquiry and on that basis alone established grounds for his disqualification. Period, end quote. Citing that decision by Bundy, which at Flaw 1978. So Flaw there, if you haven't picked it up already, is referencing the Supreme Court of Florida. The other courts get a different reference. For example, first DCA, second DCA, or other. But Flaw, if it says Flaw in parentheses and the year, that is a decision issued by the Supreme Court. And this is a newer case, 366 Southern 2nd 440. Shows you how often I use these books anymore. And the case was Bundy v. Rudd. Sure enough, right there in that book, we just found it. Bundy v. Rudd, right here. And so Bundy v. Rudd was, as I said, when the judges looked beyond the mere legal sufficiency of a suggestion of prejudice and attempted to refute charges of partiality. When the judge has attempted to refute charges of partiality, he has then exceeded the proper scope of his inquiry and on that basis alone established grounds for his disqualification. So you may remember that argument being made by Randy and Doreen in their third motion to disqualify. Again, as I've stated before, I thought it was exceptionally well written, and when you get a good writing with good citation to case law, you end up with good decisions, and that's what we have here. So, the final paragraph before the case closes states, Hales filed 3 motions to disqualify. Hales based his second motion for disqualification on the trial judge's repeated admonishment of Hales' counsel for, among other things, a supposed lack of candor before the court. In denying that second motion, the judge provided an extensive refutation of Hales' allegations. That prompted a third motion by Hales, relying therein on the judge's refutations as an independent ground for disqualification. Once a basis for disqualification has been established, prohibition is both an appropriate and necessary remedy. Necessary remedy. Writ issues is done, with one exception, and you'll see that here. What the court has, and this is included on every appellate decision that I've ever seen, and it's in bold print, not final until disposition of any timely and authorized motion under Florida Rule of Appellate Procedure 9.330 or 9.331. And then there's the citation or the copy of counsel being Doreen and Randall Shockett of Shockett Law Group, Trenton, Joshua Silverman of Silverman and Mack, LLC, Gainesville, for respondent. That would be, of course, Ms. Preston. What a day. What a day. I promised you that I would get to my brief discussions with Jeremy earlier. Once I heard this news, I couldn't wait to call him, and he was truly beside himself as we praised God together for this resolution. And we're just really grateful. Unfortunately, the system doesn't always work, but it did, and we're just grateful. We're grateful for the District Court of Appeal. We're grateful for its rendering the decision today, and so I know that many of you want to know, can I now represent Jeremy?